Hi, this is Professor Moore, and I'm recording today the first of two review videos on personal jurisdiction. This one is going to be the shorter one, and this just goes over what I call some easy ways to establish personal jurisdiction, or perhaps other ways to establish personal jurisdiction, meaning other than the framework established by international SHU and the minimum contact standards. That will be the subject of the second review video, but this one will be the shorter of the two. So some of this is a review of what we've done before. So the first easy way for a court to establish personal jurisdiction over a defendant is, of course, for individual people, their state of domicile. So whatever state a natural person is domiciled in, that state can exercise personal jurisdiction over them for any cause of action. This is sometimes referred to as the equivalent of general jurisdiction over an individual, because the individual can be subject to suit in the state where he or she is domiciled, even if the plaintiff's cause of action does not arise from anything that happened in that state. The second easy way is kind of the equivalent of that for corporations, and that is that a corporation is subject to personal jurisdiction in its state of incorporation. So once again, this is kind of the equivalent of general jurisdiction over a corporation, in that a corporation can be sued and subject to personal jurisdiction in its state of incorporation, regardless of whether the plaintiff's cause of action has anything to do with that particular state. For example, in Schaffer versus Heitner, the plaintiffs sued Greyhound Corporation in the state of Delaware, which was the Greyhound Corporation's state of incorporation, even though the actions that had led to the plaintiff's cause of action all took place in Oregon. The third easy way for a court to establish personal jurisdiction is by personal service of process in the forum state. So this is not any kind of service of process other than personal in-hand delivery. So no mailing, no faxing, no email, nothing like that. It has to be personal in-hand service. Couple of caveats about this. First of all, it only applies to individual people. So natural people, in other words, not corporations or other types of business entities. You may recall when we talked about international SHU that one of international SHU's salespeople who worked in the state of Washington was personally served with the complaint in that case. And I asked, why isn't that enough for the state of Washington to be able to exercise personal jurisdiction over international SHU? And the reason is that that particular individual was not authorized by international SHU to accept service of process on behalf of the corporation. So you can't just find an officer of a corporation and hail her down and serve her with process. and expect that will suffice for personal jurisdiction over the corporation that she's president of in that particular state. That won't work. It only works for individuals. The second thing that I wanted to remind you of is that Burnham versus Superior Court had no majority opinion. And so while all the justices agreed that jurisdiction over Mr. Burnham in the state of California, based on his service of process in the forum, all the justices agreed that that was constitutional. But they disagreed on the reasoning, with Justice Scalia taking the position, basically, that service of process in the forum state always establishes constitutional jurisdiction, with the possible exception of the person being there by force or through some sort of fraud. But Justice Brennan's opinion, holding out the possibility that it might not be fair or reasonable to base personal jurisdiction over an individual solely on the fact that they were served with process in the forum state. So in other words, Justice Brennan believed that the minimum contact standard of international shoe should be applied to this situation of personal service of process in the forum state. However, neither one of those opinions garnered 5 justices, and so we really don't have a clear idea out of that case as to the continuing viability of Pennoyer's absolute statement that personal service of process in the forum was always enough for the court to exercise personal jurisdiction. So I would say that in 99.99% of the time, personal service of process on the individual in the forum state is constitutionally sufficient. However, in a very, very oddball factual situation where it does seem unfair or unreasonable to subject the defendant to personal jurisdiction in a given case, the argument is still open to be made. Other ways of establishing personal jurisdiction involve consent by the defendant to personal jurisdiction and waiver by the defendant of the defense of personal jurisdiction. So there are many ways to consent to personal jurisdiction, some of them explicit and some of them implicit. The first and most obvious is simply if you voluntarily appear in the forum and defend the case on the merits, you've consented to personal jurisdiction. And that phrase, voluntary appearance in the forum, actually stems from Pennoyer versus Neff. The form that is printed on the right side of this screen is the attorney appearance form used in the Federal District Court for the Northern District of Illinois. And this is, when you sometimes hear the expression appearance, this form is what they might mean. An appearance is hereby filed by the undersigned as attorney. Now, the Northern District of Illinois is, of course, a federal court, and so you could file this appearance and still not consent to jurisdiction. You would also file a motion to dismiss for lack of personal jurisdiction, and that would preserve your right to make that defense. What I'm saying is that when you hear the word appearance, it might have somewhat different technical meanings depending on which court you're in. Sometimes an appearance is simply referred to as when the defendant shows up and files an answer on the merits. Sometimes it's when they file a form like this one. But basically what this phrase means is that in some manner the defendant begins to defend the case on the merits and never raises the defense of personal jurisdiction. In such an event, the defendant is held to have voluntarily appeared in the forum and thereby has consented to personal jurisdiction. The second way that a defendant, well, actually it wouldn't be a defendant, that a plaintiff could consent to personal jurisdiction is by the use of court procedures. Now, I think it should be fairly obvious that if a plaintiff files a lawsuit in a particular state, the plaintiff is, of course, consenting to the court's personal jurisdiction over her, simply by the fact of them filing a lawsuit. But what if the plaintiff files a lawsuit, let's say in the state of Oregon, and the defendant then turns around and files a counterclaim against the plaintiff? And the plaintiff says, oh, but wait a minute, I don't consent to the court in Oregon having personal jurisdiction over me to decide this counterclaim. I only consented to personal jurisdiction so that the court could decide this complaint. And the Supreme Court in Adam versus Sanger, which is cited on page 296 of your casebook, held that if the court in which you file this lawsuit has a procedure whereby the defendant can file a counterclaim against you as plaintiff, then by filing your lawsuit, you've consented to personal jurisdiction over yourself if the defendant should file such a counterclaim. So it's kind of a matter of common sense. A third means of gaining consent to personal jurisdiction is through what is known as a forum selection clause. And these are extremely common in contracts. So anytime you have the opportunity to have one of these contracts of adhesion forced upon you, I'm being a little bit sarcastic, it's likely to have something like a forum selection clause in it, such as this one from the Carnival Cruise Line's ticket contract. This is their current ticket contract, which says, it is agreed by and between the Guest and Carnival that all disputes and matters whatsoever arising under this contract or the guest's cruise shall be litigated, if at all, before the United States District Court for the Southern District of Florida in Miami, or as to those lawsuits to which the federal courts of the United States lack subject matter jurisdiction, before a court located in Miami-Dade County, Florida. So the effect of this forum selection clause is to say that you, the guest, by signing this contract or even by using this ticket, have consented to personal jurisdiction in the state of Florida. The Supreme Court has upheld the validity of forum selection clauses in contracts in case after case, including one based on the Carnival Cruise Line's ticket. Now, this isn't strictly a personal jurisdiction slide, but since I just talked about forum selection clauses, I wanted to make sure that you understand the difference between a forum selection clause and a choice of law provision. So here's an example from the Apple software license agreement that you undoubtedly clicked on if you're using an iPhone, iPad, or iPod Touch. Paragraph 12 of that agreement says, "This license will be governed by and construed in accordance with the laws of the state of California." So if there's any dispute that arises between you and Apple regarding this license, that dispute is going to be governed by the law of the state of California. That does not mean that all lawsuits must be brought in the state of California. It does not mean that you have consented to personal jurisdiction in the state of California. It just means that wherever you do end up having a lawsuit with Apple over this license agreement, that dispute will be governed by California law, specifically probably California contract law, or perhaps California consumer law, depending on whatever the dispute is. Now, you may recall that in the Burger King case, one of the factors that the court relied on in upholding the constitutionality of personal jurisdiction over Mr. Rutzowitz was that his franchise contract with Burger King had a choice of law provision, providing that in case of any dispute arising under the contract or the franchise agreement, that dispute would be governed by Florida law. And the court looked at that as a factor to be considered in whether it was foreseeable to the defendant that he could be hailed in front of a Florida court with regard to a dispute arising out of that contract. The reasoning being something like, you saw that if you were going to get in a dispute with Burger King, it was going to be controlled by Florida law, so it can't be that much of a shock to you that you might be hailed into court in Florida. But it's not an automatic thing. In other words, just because a state's law is deemed to govern any disputes, that does not mean that that state is going to necessarily have personal jurisdiction over the parties to the agreement. The final method that's mentioned in your book of consenting to personal jurisdiction is this idea of implicit consent that is deemed by some kind of state statute to have been obtained from the defendant. So the most recent case that we read that had this type of state statute was Schaffer versus Heitner. Actually, the statute on this screen was not in effect at the time of Schaffer versus Heitner. But after that decision, the Delaware legislature passed this statute that you see in front of you. And what it says is that if you accept an appointment as a director or an officer of a corporation that is incorporated under Delaware law, then by agreeing to serve in that capacity, you will be deemed thereby to have consented to the appointment of the registered agent of that corporation as an agent upon whom service of process may be made in all civil actions brought in this state, meaning the state of Delaware, in any action for the violation of your duty as a director or an officer, something that specifically arises out of your duties as a director or officer. So even if a particular director consents to be a director of a Delaware corporation, but doesn't know about this statute still deems that person to have agreed to subject themselves to personal jurisdiction in Delaware in any action that arises out of their duties as a director of that corporation. An earlier example that we saw of this implicit consent idea was in the Hess versus Pulowski case, where the Massachusetts state statute said, if you drive a car in our state and you cause an accident, then you are implicitly consenting to personal jurisdiction in this state by your use of highways in the state of Massachusetts for any case that arises out of your use of the vehicle in the state of Massachusetts. Somewhat related to consent, but a little bit different, is the idea of waiving the defense of personal jurisdiction. And the first way that you can do that is simply by not raising the defense in time. As we are going to discuss, I believe, later in the semester, personal jurisdiction is actually a very easy defense to waive if you don't do it pretty quickly at the beginning of the lawsuit. The ins and outs of the waiver are presented in Rules 12G and 12H of the Federal Rules of Civil Procedure, and you don't have to get into those in detail right now, because you will be getting into those in detail later on in the semester. But the point here is that you need to raise this defense very early on, and if you don't do so, you have waived it. Another less common means of waiving the defense of personal jurisdiction is by failing to respond to court-ordered jurisdictional discovery. So what do I mean by that? Well, this is what occurred in the Supreme Court case of Insurance Corporation of Ireland, and I'm not even going to attempt to pronounce the defendant's name because I will mangle it. But in any event, the plaintiff was this French company, and they had an insurance policy with this Insurance Corporation of Ireland. They sued in Pennsylvania, and the insurance company objected to personal jurisdiction by filing a motion to dismiss for lack of personal jurisdiction. Well, the plaintiff, French company, asked the court to order jurisdictional discovery, saying, you know, we don't know how many insurance policies this company might have actually issued in the state of Pennsylvania. We need more information, in other words, about what are the defendant's contacts with the state of Pennsylvania. And the court, in fact, ordered that discovery to be had. And Insurance Corporation of Ireland said, well, you don't have personal jurisdiction over us, court, so you can't order us to comply with jurisdictional discovery. And the court said, well, if that's the way you feel, then I'm going to hold that you've waived your right to contest personal jurisdiction because you're not obeying my order. And that is what happened, and it went up to the Supreme Court, and the Supreme Court upheld what the district court had done, saying that if a defendant is going to come in and into federal court and raise the defense of lack of personal jurisdiction, it basically is raising the entire procedural apparatus of the Federal Rules of Civil Procedure when it does that. And one of the things that can happen to you when you come in and make that motion is that you might be subjected to jurisdictional discovery. And so you have to comply with the order of the court while that motion is being ruled on. And so this is, like I said, far less likely to happen than the first type of waiver, which is simply by failing to raise the defense in time. So that completes my sort of wrap-up video, And I will be recording a second video that will review specific jurisdiction and general jurisdiction in more detail.